Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to the Christmas Special podcast. In previous years we've done Christmas specials including songs about employment lawyers or for employment lawyers, books for employers, a mash-up episode, you really don't want to ask about that one. And this year, well, we thought we'd do something a little more conventional and have the top 12 employment cases. But to ensure that we have some changes to our normal format, and partly to say thank you to them, I've asked two of the associates in the London employment team, Kayne Jonsson and Victoria Jonsson, to co-present the podcast with me. They've worked all year to put together the scripts and do the background research to the podcast episodes that I do, and I thought it'd be fun to have them on board for the Christmas special. So welcome, both of you.
Thank you. Thank you.
I also thought it'd be an opportunity for us to use up the spare bottle of champagne in my office, which I got from a grateful client, and have an appropriate festive atmosphere. We got as far as renaming this the Popcast before we remembered that the compliance gnomes would say bar humbug and veto the idea. Well, we picked 12 cases of particular significance for employers. Why 12, I hear you ask? Well, we know various other firms put out written materials on top 10 cases, and on the basis of never mind the quality, feel the quantity, we thought we'd go with 12. And it did allow me to suggest to Kayne and Tori that I expect them to sing a version of 12 Days of Christmas, to which they pointed out it would be better than my singing the Top of the Pops theme tune from my youth if we're going to do a countdown of key cases. So we're not going to do that. But we have picked 12 cases, and well, in all seriousness, it's quite difficult to reduce the list down much below that because there are a number of really quite significant cases for British employers this year. We're not, contrary to popular request, going to be doing cases about any of the wilder factual employment claims, such as, well, the meerkat case involving employees at London Zoo, or the guy who claimed age discrimination having been asked to dress up as Father Christmas because he felt it was discriminatory to him on the grounds of his age. But we are going to look at a number of the really key cases that have come up, most of which, but not all of them, we've covered on the podcast. As always, the podcast is going to be available via iTunes and Mayor Brown's intranet, and also YouTube and Twitter. And I'm going to see if I can get the AV guys here to put a photograph of a meerkat on the YouTube version, just to see if the compliance people notice. And, on a more serious note, stay with us to the end of the podcast for the Christmas competition, with a prize of no discernible value whatsoever, and a podcast summary document which does have real value, I promise you. So, we're going to each do 4 cases. Kayne, do you want to start off?
Absolutely, Nick. So we're starting off today's podcast with the case of CLFIS UK Limited and Reynolds, which made it onto our top 2015 list. Now, this is a Court of Appeal decision that we covered in our May podcast this year, and it looks at whether a tribunal in the context of a discrimination claim should focus only on the motivation of the person who makes the decision to dismiss, or whether this assessment should be extended to include those whose views impacted the decision. Now, in this case, Dr. Reynolds' dismissal was not in itself a discriminatory act, but was allegedly rendered discriminatory by the alleged motivation of others who were indirectly involved in her dismissal. However, the Court of Appeal disagreed with this, upholding instead the tribunal's decision to consider only the general manager's motivation as the decision maker. The court referred to the case as a case of tainted information and concluded that the EAT was wrong to allow Dr. Reynolds' appeal. The EAT held that it would be unfair for the General Manager's Act to be held as discriminatory on the basis of someone else's motivation. So we picked this case for our top 12 as we felt that it is relatively common for employers to have a number of parties involved in providing information to a decision maker. Indeed, it's quite surprising that this point hasn't been addressed specifically by the courts before. And of course, had it gone the other way, it would have opened up the field for claimants to extend the parameters of who the tribunal should look at when considering their discrimination complaints. However, this decision does highlight the importance for employers of choosing a decision maker with caution and considering their motivation very carefully. Equally, if you have joint decision makers, this case is a reminder that employers should look at the mental processes of each in turn. Now, I think this case is also an important reminder of the need to be clear about whether you have joint decision makers or a single decision maker, but possibly with support from, for example, HR. And not to give it away that the case of Ramphal is in our top 12 today, but this is, of course, an issue that gets picked up in that case. Now, it may be that as a result of this case, claimants now seek to look beyond the dismissal as the act complained of, extending their claim by pleading that the information on which the decision was based was discriminatory and that each separate act is appropriately pleaded. So let's see what 2016 brings.
I think you can certainly see that if that case had gone the other way, it would have made life much more difficult for employers.
Quite.
Tori, what have you got for us?
So this is the case of Mrs. Lodge and dignity and choice in dying and compassion in dying. Now this is an EAT decision from March this year, and the case considers the territorial reach of the rights contained in the Employment Rights Act 1996. As a brief recap, the case concerned an employee, Mrs. Lodge, who sought to bring a claim for unfair dismissal and whistleblowing at the Employment Tribunal against her joint employers, who were both defendants in the case. Mrs. Lodge is an Australian citizen, but at the time her employment started, she lived and worked for the defendants in London. However, only a few months later, Mrs. Lodge and her family decided to move back to Melbourne, and the defendants agreed that she could continue in her role as head of finance, working remotely from Australia. And she did this for 4 years. Mrs. Lodge's employment contract was governed by the laws of England and Wales, and the parties submitted to the exclusive jurisdiction of the English courts. However, there was subsequently a breakdown in the relationship following an unsuccessful grievance raised by Mrs. Lodge, and ultimately Mrs. Lodge resigned and claimed constructive dismissal. Therefore, the big question was whether Mrs. Lodge was entitled to bring a claim at the UK Employment Tribunal, and the EAT found that she did have a sufficiently strong connection with the UK in order to bring her claims. Now, this case is particularly important as it highlights the different factors which are useful to consider in a case regarding territorial jurisdiction, including 1. What the governing law of the employment contract is, 2. Where any disciplinary or grievance procedures were carried out, 3. Whether the work is being carried out for a UK office, and 4. Whether the employing entity is based in the UK. Also importantly, it's useful to take away that the EAT didn't consider it to be significant that Mrs. Lodge chose to work in Australia for family reasons, as opposed to having been asked to relocate there for business reasons. Nor did it say that it was important it was a permanent move, rather than being merely a temporary post. To that extent, the goalposts do seem to have moved slightly. Ultimately, this is a good case to bear in mind if you are considering setting up a similar arrangement. For example, if there is more than one company in your group, you could consider whether you wish to move the contract of employment so that it is no longer with the English employer, or perhaps change the choice of law clause in the contract, or ensure that the individual does not report into line management based in Great Britain.
Thanks, Tori. Sticking with the international theme, the first case that I picked up is PETA and EMC Corporation, and that's the Court of Appeal decision from July this year dealing with territorial jurisdiction. And specifically, the case looked at why employers who are not domiciled in the UK may find they simply cannot sue the employee in a jurisdiction specified by them, even if they have an exclusive jurisdiction clause in their employment contract. Instead, employers are obliged to bring any proceedings against their employees who are domiciled in England in the English courts. And this was an inevitable top 2015 case, as not only is it's a really key area for international employers, but this obligation to bring proceedings in the UK may have a crucial impact on the outcome of the underlying dispute. For a reminder of the general principles under EU employment law and where employers and employees can sue one another, we cover this in episode 76 of our podcast, but as you may recall, Mr. PETA was employed by EMC Europe Limited, which is a subsidiary of EMC Corporation, an American company. He was sued in the US by the holding company, who sought to enforce post-termination restrictions and to rescind recent awards of stock in reliance on an express jurisdiction clause in the stock plan, which Mr. Petter had freely entered into. Mr. Petter asked the High Court judge in England to grant an anti-suit injunction, but this was refused on the grounds there was no reason to believe the American courts would pay any attention to the grant of such an injunction. Well, Mr. Petter appealed, and the Court of Appeal confirmed that this was a dispute that engaged the relevant EU provisions dealing with jurisdiction in the employment context. Therefore, although the party suing in the USA was not technically the employer, but the holding company of the employer, and the document on which it was suing was not the contract of employment itself, it was the stock plan, the Court of Appeal took a wider approach than looking at the precise contractual documentation and the precise identity of the employer. This was, in reality, an employment dispute, and therefore the EU jurisdiction laws were engaged. It was, as the Court of Appeal put it, quote, intrinsically bound up, unquote, with the contract of employment, and therefore the Court of Appeal granted the anti-suit injunction. We picked this case for our top 12 as it's a key decision for international employers who employ individuals in member states, as will almost inevitably be the case. Increasingly, international employers will have either common terms and conditions across a variety of jurisdictions or may have common employment documents globally. Both in this case and in the previous Semengo-Turner case, the issue related to common bonus terms contained in a separate document and issued by the holding company. And such documentation, let's face it, is pretty common. Therefore, the issue as to where any disputes have to be heard is a key one for both employers and employees, and may well determine the outcome of the entire dispute. Clearly, following the Petter case, the courts are going to adopt a wide approach to what constitutes a contract of employment. Therefore, if the relevant document is entered into with a company within the employer's group, and it's entered into in connection with those employment arrangements, then the EU provisions dealing with jurisdiction in the employment context are going to be engaged. At the moment, there doesn't appear to be any clever drafting or something like that will get around that particular problem, and it is, of course, not commercially practical to have all senior employees operating as consultants, so you stop them being employees altogether. If post-termination restrictions are important to the employer, then it's necessary to recognise that you may need to enforce them in the country in which the employee is domiciled. As such, it may be necessary to adjust the standard global or transnational provisions to provide some sort of adaptation for local nuances. Clearly, taking local law advice when drafting the rules of any such global stock plan, or before operating any forfeiture provisions or restrictive covenants, is going to be of paramount importance. So, Kayne, your next case, Leeds Football Club. What have you got against Leeds Football Club?
Yes, this is my next pick for the top 2015 cases. And this was a High Court decision that we actually covered in our podcast in March this year. And it considers an employee's repudiatory conduct and subsequent dismissal due to a breach of the implied terms of mutual trust and confidence. So to give you all a quick summary, Mr. Williams was employed by Leeds United Football Club on oral terms and conditions. So there was no written contract or particulars of employment drawn up between the two parties, but the oral terms set out that Mr. Williams was to be employed on a salary of £200,000 with benefits and terminable on 12 months' notice. In brief, Mr. Williams was then given notice by reason of redundancy. Although, unbeknown to him, the club had begun investigating his emails and expenses prior to that dismissal, looking for a possible way to dismiss him without paying notice. Now, as a result of these investigations, shortly after giving Mr. Williams his notice, the forensic investigators discovered an email sent from Mr. Williams' leedsunited.com address more than 5 years earlier, and this email contained a number of pornographic images. The club argued that the conduct taken as a whole amounted to gross misconduct, entitling it to dismiss Mr. Williams summarily over 5 years later. Mr. Williams subsequently brought a claim in the High Court for breach of contract. So why is this case important? Well, the fact that the club had decided to make Mr. Williams redundant and then actively set out to look for evidence of wrongdoing to justify dismissal without notice was interestingly considered irrelevant by the High Court. The court concluded that under the basic rules of contract law, an employer is entitled to rely upon conduct amounting to a breach of contract to resist a claim for damages for wrongful dismissal. And that's irrespective of the employer's motives or when the conduct was discovered by the employer. Obviously, if the club had known about the email before the dismissal and done nothing, then the outcome here would likely have been very different. So as unsavoury as this top 12 case seems, it does demonstrate that employers who are facing an extended notice pay claim may have a possible escape route. The club was entirely opportunistic in its approach here, but the High Court judgment sets the bar relatively low for employers to decide that they are going to go back through email traffic, etc., in the hope of turning up something similar. So it seems that time by itself isn't going to get an employee off the hook if a number of years before they had sent an email that can be judged as obscene.
And please note, whilst I might be able to get an image of a meerkat into our YouTube podcast version, I don't think we'll get any of the images Mr. Willis had sent
Let's
onto
avoid that.
Yes, let's avoid that. Good plan. Good plan. Tori, what's your next case?
Now we turn to the case of Chesterton Global Limited and another v. Nur Mohammed. Now this was an EAT case from April this year, and the case considers the public interest test provisions in the whistleblowing legislation and the meaning of the words in the public interest that were recently inserted into the Employment Rights Act. As a way of a brief overview, Mr. Nur Mohammed was employed by the estate agent Chesterton as a director of the Mayfair branch. Mr. Nur Mohammed alleged that on 3 separate occasions he made protected disclosures stating that he believed that Chesterton was carrying out intentional manipulation of its accounts. He believed that these inaccuracies resulted in reduced bonus and commission payments payable to 100 Chesterton senior managers, including Mr. Nur Mohammed himself. Now, in relation to the issue of whether the protected disclosures were made in the, quote, reasonable belief that they were in the public interest, unquote, the Employment Tribunal concluded that so long as a section of the public would be affected by the inaccuracies, as opposed to simply the individual himself, this was sufficient for a matter to be considered in the public interest. Therefore, the tribunal found that the 100 senior Chesterton managers were a sufficiently large group of the public to satisfy the public interest test. Following this decision, Chesterton appealed to the EAT, but the EAT rejected the appeal and held that a worker making protected disclosures only has to have a reasonable belief that the disclosure is made in the public interest, and the EAT didn't need to determine objectively whether or not that protected disclosure actually was in the public interest. Now, I think this case is significant, as it's the first case to test the proper meaning of the newly introduced public interest test in the whistleblowing legislation. It's interesting to see the tribunal demonstrate that this is a relatively easy hurdle for an employee to clear. This is especially so given that the tribunal confirmed that even a relatively small group may be sufficient to satisfy that public interest test. It seems not to matter that the primary reason for the disclosure is the employee's own interest or advantage, so long as a sufficient group of other employees happen to also be affected. I think this case is also a useful reminder that the employee need not even be correct about the facts that they are disclosing. The employee can still be afforded protection under the legislation so long as they can demonstrate that they had a reasonable belief at the time of the disclosure that it was in the public interest.
You read a case like this and you can't help feeling it wasn't quite what the government intended to be in the public interest and how the test was supposed to operate, but it does follow with what the legislation now says.
Absolutely.
Okay, my next one, BBC, British Broadcasting Corporation and Roden. And this was an EAT case from the June podcast, which considers a permanent anonymity order to be made by the Employment Tribunal. And the order had been made by the Employment Tribunal to protect Mr. Roden's identity, where allegations of serious sexual assault that had been made against him were disclosed during the course of a tribunal hearing which he brought against the BBC. And a point to note is that the case dealt with anonymity orders made by an employment tribunal after it had given in its decision, not made during the running of the case itself. And obviously it doesn't take a brain the size of a planet to work out, because we know his name is Mr. Roden. We know what the outcome of the case was. Well, following Mr. Roden's dismissal, he brought a claim of unfair dismissal, amongst others, in the tribunal. The claims were dismissed, but the decision was delivered on an anonymised basis, and permanent anonymity was ordered even after the judgment had been given, and that was on the basis that it can be difficult for an individual to shake off sexual offence allegations once they've been made public. Following the tribunal's decision, the BBC notified Mr. Roden and the tribunal of its intentions to inform interested parties of Mr. Roden's identity and to provide them with a copy of the tribunal's decision. And hardly surprisingly, Mr. Roden objected to this, and a further tribunal hearing was convened in respect of the tribunal's permanent anonymity order. And in this hearing, the tribunal refused to set the anonymity order aside because they were worried about the risk of the public concluding that Mr. Roden had actually committed the offences when, in fact, they'd not even been the subject of the trial, the employment trial. BBC appealed. The appeal was upheld. In the EAT's view, whilst the identification of individuals such as Mr. Roden may be controversial, the public can be trusted to distinguish between an allegation and a finding of guilt. The EAT also concluded that there is a public interest in naming such individuals so that other potential victims may come forward. Consequently, the EAT concluded there was no rational basis for the anonymity order, and the BBC's appeal was allowed. We chose the case for our top 12 as it demonstrates a continuing movement by the courts away from granting anonymity orders on the basis of the consequences that would flow from unproven allegations. The case shows a reluctance on the part of the courts to overturn the principle of open justice, despite issues of a sensitive nature thereby being made public. Employers should therefore consider this emphasis by the courts on open justice in relation to any material made public by them in the claim form, or in their case in the defence. The case demonstrates that even where issues are of a sensitive nature, they may well be publicised outside of the tribunal room quite safely. It seems unlikely the courts will be keen to permit restrictions or orders on the basis of reputational rights alone following this particular case. So it's therefore essential for employers to assume that information presented to a tribunal will make its way into the public domain unless there are really quite strong arguments against it. So that's BBC and Roden. Kayne, what's up next?
Next, I've picked the case of Mrs. Braithwaite and others and HCL Insurance BPO Services Limited. And this is an EAT decision that deals with an indirect age discrimination claim made under the Equality Act. Now, the claim involved a number of employees from different companies who had all transferred to HCL under the service provision rules of TUPE. And then down the line, HCL was facing continuing losses and decided to address the situation by cutting the costs in relation to its employees. And it did this by requiring all of its employees to agree to new terms and conditions, and these reduced their benefits and holiday entitlement, etc. If they didn't agree to the changes, they would face dismissal. And obviously, as employees built up greater entitlements under their existing contracts by virtue of longer service, this inevitably put older employees at a particular disadvantage here. And the tribunal found that the requirement to enter a new contract was a PCP, but that here the PCP was objectively justified, and the EAT also agreed with this. Now, what's really interesting about this case and why it appears in our top 12 is what the EAT said about the justification of HCL's policy to cut costs. The employer had argued that the justification of the policy was not simply a desire to save costs, but a desire to ensure the viability of the business and to have market competitive and non-discriminatory terms and conditions. So in this case, the employees contended that alternative proposals had been put forward to the employer, such as changes being phased in, for example, and that these proposals hadn't been adequately considered by HCL. However, the EAT said that the Employment Tribunal was entitled to conclude that this would actually delay the achievement of a legitimate aim, and delaying the changes would have just continued to put in place conditions which aren't actually market competitive and which are potentially discriminatory. So ultimately, although the employees mounted this attack on the justification of the PCP, the employer was actually able to withstand this attack, and the employees couldn't come up with any better way of achieving the legitimate aims of the employer. And that's exactly what makes this one of our important cases of 2015. And the employer in this case demonstrated that it handled matters well. it had carried out an extensive consultation process, and it had clearly thought about what was being proposed, and therefore it was able to respond to the criticisms put up by the employees. So I'd say the key sort of takeaway message from this case is that preparation really is everything, and we would recommend that employers who are thinking about introducing changes such as these read this case and consider the arguments that are put forward by the employer here to defend itself, because I think these could prove invaluable to employers.
Certainly it's stuff that we've seen a lot of with employers looking to change terms and conditions, and so I think it was a really good example of how to go about
Definitely, really useful guidance, I think.
Good. Tori, what have you got?
Yeah, so next we have the case of Braganza v BP Shipping Limited. Now, this was a Supreme Court decision from June this year, and whilst the precise case relates to a decision by the employer not to pay death in service benefits to an employee, it is of potentially much wider significance. By way of a quick summary, the case involved an employee working on a ship owned by BP Shipping Limited who disappeared during the night whilst on a voyage. If it was found that he had committed suicide, then no death in service benefits would be payable. Otherwise, his family would have been entitled to the death in service benefits. Under his contract, the decision as to whether or not death in service benefits were payable was to be determined in the opinion of the company. Following this, a report was conducted into his disappearance, and it was concluded that the likelihood was that the employee had committed suicide. This report seemed to have then been adopted by the senior employee at the employer, who was in charge of deciding whether or not to pay out those death in service benefits. And as a result, no death in service benefits were paid, and the family then brought a claim which won in the High Court, lost in the Court of Appeal, and then the matter went up to the Supreme Court. Now, the key question was in relation to the standard expected of an employer when exercising its discretion when forming an opinion, and in particular whether the public law test of Wensbury unreasonableness should also be applied in private law cases. The Supreme Court accepted that the Wensbury test should apply in such cases. Therefore, employers should first take into account all relevant factors and disregard all irrelevant factors when coming to a decision. And secondly, the decision should not be one that no reasonable decision maker could have reached. Now, the reason we wanted to mention this case in our top 12 is that the ruling by the Supreme Court is potentially very significant and goes far beyond the sad facts of this case. The courts have for some time accepted that there is a degree of control implied into the employer's exercise of a discretion. However, this is the first case where the Wensbury test has been applied in this way, and I think this clearly opens the way for more challenges to the exercise of an employer's discretion. That being said, I do think this case raises the issue once again as to whether an employer can exclude implied terms. For instance, what is to stop an employer from putting a general clause into its contracts to say that when exercising its discretion, there are to be no restrictions which are applied to the exercise of that discretion? I'm sure we're going to see cases in this area before too much longer. Finally, I think this case is indicative of the approach of the courts in respect of employee rights. Even if we do not see any significant extensions to statutory employment rights in the new year, I do think that this case indicates that judicial activism could be a source of expansion for employee rights.
Thanks, Tori. Okay, my next case is the Rampal and Department of Transport case, which is an EAT decision from September this year. And the case focuses on the apparent improper influence that the Department for Transport's HR team had in relation to a disciplinary procedure which resulted in the dismissal of an employee, Mr. Rampal. By way of quick summary, the case concerned a disciplinary procedure conducted into alleged misconduct on Mr. Rampal's part. The manager for the Department for Transport, Mr. Goodchild, was appointed to carry out the investigation. He was inexperienced in conducting disciplinary investigations and hearings, and as you'd expect, he sought and received help and support from the HR team. After the disciplinary hearing, he sent the first draft of his report to HR, and the report was relatively critical of Mr. Ramphal, but also contained a number of positive findings in his favour and a recommendation that he'd get a final written warning. Following this, there were extensive communications between Mr. Goodchild and the HR team, which went over something like 6 months, during which time there were a number of changes made to the report, and the key changes included the removal of the positive findings about Mr. Ramphal's conduct, and the sanction was increased to dismissal. Accordingly, he was dismissed, and accordingly, no surprises, brings a claim for unfair dismissal. The tribunal judge decided that the disciplinary investigation had been reasonable, and the decision to dismiss fell within the band of reasonable responses. But, the EAT disagreed, allowed the appeal. The EAT judge remitted the matter to the same employment tribunal judge to reconsider whether the influence of HR was improper, and if so, whether it had a material effect on the ultimate decision of Mr. Goodchild. Well, the case is concerning for a number of reasons. The main concern is that the employment judge makes a number of statements at the EAT stage about the interaction between HR and an investigating or disciplining manager in a disciplinary process, which seem to be potentially quite far-reaching. If read literally, some of the statements seem to be suggesting that HR advisor's role is simply limited to advice on policy and procedure and ensuring consistency with the past treatment of similar offences. The key issue is these generalised statements, and they are in quite direct and blunt terms, may go beyond the current state of the law, or certainly what the law had understood to be. And in the wake of this decision, we're left in a position of some uncertainty as to the extent to which an investigator can ask for advice or assistance and take those points on board in coming to his or her own decision. If HR makes suggestions and the investigator looks at them, accepts the validity of what HR are saying, and then adjusts the report accordingly, it's questionable whether the investigator now has to disclose the substance of that exchange to the employee facing the charge and invite the employee's comments, rather than simply state he or she has developed his or her thinking. If the case doesn't get appealed, and I don't know whether it will be, then maybe the employment tribunal judge will stand by his earlier decision that Mr. Goodchild's report was a product of Mr. Goodchild's investigation, notwithstanding the input from HR. But in the event that this doesn't happen, I'd suggest take a listen to podcast 78, because we made, I think, 6 recommendations for employers on steps they should take, things they should do in the light of this judgment. So, Kayne, your last case.
Yes, my last pick of the day, and that's Jonsson and Docklands buses. And this is a case we covered in podcast episode 71 if you want to get our full views on this case. And we picked this case for our top 12 as the question of whether a disciplinary process should be put on hold to deal with a grievance is a common question faced by many employers. Now, as you may recall, Miss Jonsson was employed as a bus driver by Docklands Buses and was subject to formal disciplinary proceedings due to poor driving. And during the course of those disciplinary proceedings, Miss Jonsson raised a number of grievances about some of the managers involved in her disciplinary. Now, despite those grievances raised, Docklands Buses didn't put the disciplinary on hold, but instead continued with and completed her disciplinary process, which subsequently resulted in her dismissal. Now, both the tribunal and the EAT rejected Miss Jonsson's claim for unfair dismissal, with the EAT concluding very firmly that Docklands Buses was not obliged to put the disciplinary investigation on hold until it had dealt with her grievances. So why did we pick this case? Well, we felt it's a helpful decision for employers in that it supports the view that there is no automatic need to postpone any disciplinary proceedings to deal with grievance allegations subsequently raised. So in circumstances where an employee subsequently raises a grievance, employers should be alive to the fact that they may need to adjust who hears the disciplinary to ensure there's no conflict of interest for the manager who's conducting the disciplinary hearing that's ongoing at the same time. Clearly, if there was an expectation that by raising a grievance, a disciplinary process could be potentially delayed or derailed, there would be lots of grievances raised. However, I think something that's important here is to recognise that this case doesn't say that it will never be necessary or appropriate to delay the disciplinary hearing. And, inevitably, the outcome of each case is going to turn largely on the facts of that case.
Well, certainly I was very much in favour of this going into the top 12, because a number of times we've seen employees try to delay or defer disciplinary hearings by raising grievances, and generally we've always pushed ahead, and so far we've always been able to defend that decision. But it was helpful to see the EAT in this case endorse that approach. But taking your point entirely, that it doesn't say you never have to.
It's not an absolute.
You need to think about it. Yeah. Okay. Tori, what's your last case?
My final case is the case of the Land Registry v Miss Houghton and others. And this was an EAT decision from back in February this year. This case concerns a claim for discrimination arising from disability under Section 15 of the Equality Act. And as way of a brief summary, the Land Registry operated a discretionary bonus scheme. Under the terms of the scheme, an employee who received a formal written warning in respect of a sickness absence during that year was not eligible to receive a bonus, and the manager had no discretion to ignore such sickness-related warnings. This was the case despite the fact that the managers did have discretion to ignore conduct-related warnings under the bonus scheme. Each of the claimants in the case had a number of sickness absences which were all attributable to their disabilities. The Land Registry had made a number of reasonable adjustments, but despite this, the claimants had received written warnings for their absence. Therefore, the claimants were not entitled to a bonus under the rules of the scheme, and the Employment Tribunal held, and the EAT agreed, that the claimants had received a warning for their disability-related sickness, which automatically disentitled them from participation in the bonus scheme. Therefore, the non-payment of the bonus was a direct consequence of their disability. As such, the claimants succeeded in the initial hurdle of showing a disability-related detriment, and the burden shifted to the Land Registry, who had to justify this. Whilst the Land Registry did establish that it had a legitimate aim, which was to operate the bonus scheme that rewarded good performance and attendance, the tribunal found that the non-payment of the bonus to the claimants was disproportionate. Now, although this case didn't establish any new principles of law, I thought it was a very helpful case as it does illustrate some practical issues. First, employers may not be aware that they would need to justify the exclusion of employees with sickness absence warnings. Therefore, they may never have considered whether the steps that they were taking were proportionate. This was particularly problematic in this case, as once the tribunal had established that there was a link between the individual's status as disabled employees and the unfavourable treatment, it then had to go on to justify that. It was unable to do this, and the fact that it had never turned its mind to the issue before was no doubt challenging. The second point to take away is that if the policy for the sickness absence warnings had been the same as the policy for other warnings, and the managers had discretion to decide whether or not to disregard such warnings, the decision might have been different. So in other words, it may have been that the disparity between the approach by the employer to the two different types of warnings was the real thing that caused the problem in this case. However, ultimately, the case is a really good reminder that employers should be alert to the need to justify neutral rules and practices if they are applied to a protected category of individuals.
Yes, and I think this case is a good illustration of the way that disability discrimination challenges can sometimes trip employers up because they may not have considered the particular challenge that's coming in or not thought how they would justify apparently neutral rules.
Yes, definitely.
Okay, so my last case is not really a case. It's a change of direction. As we've discussed in our podcast on more than one occasion, the UK's collective redundancy obligations are triggered where there is a proposal by the employer to make 20 or more employees redundant at one establishment in a defined period. Bizarrely, in my opinion at least, there are criminal sanctions involved if the employer fails to submit the appropriate form to the relevant government authority, giving that authority sufficient advance notice of the redundancies. Under Section 194 of TULCRA, the employer needs to file the HR1 form 30 days before the first dismissal takes effect, if there are between 20 and 99 redundancies, and 45 days before the first dismissal, if there are more than 99 redundancies. The sanction for failure to submit HR1 form in the appropriate time is a criminal one. And although the employers have, in theory, faced the threat of criminal proceedings, for some time. This legislation has been on the statute books in the same form since, I think, 1975. No criminal proceedings have been brought before 2015. However, we are aware of at least 2 entirely separate cases where prosecutions have been started against company directors who were allegedly responsible for failure to put in an HR1 form in time before the redundancies occurred. Happily, the first case which got to trial saw the directors acquitted because they were able to show that they believed the business could be saved without collective redundancies occurring. The second case is continuing as far as I'm aware. Clearly, if the government is now proposing to look actively at bringing criminal prosecutions against employers who fail to comply with an obligation to submit HR1 form within the appropriate timescale, well, this is going to be a radical change in approach. In practice, it will drive more employers into collective consultation exercises because the employer will be prevented from making snap redundancies for fear of criminal consequences. In those circumstances, the employer might look to consult in the period before the dismissals can safely take effect. However, on the other hand, of course, some cases announcing the threat of redundancies might be the very thing that tips a business over the edge. And so this is a double-edged sword. But the main point is the arrival of a real threat of criminal proceedings against directors is not going to be a welcome development for directors of companies in Britain where there may need to be collective redundancies. So those are our 12 cases, and thank you very much indeed for listening. We hope you find our annual summary helpful. We promised a Christmas competition, and so here it is. To win a prize of no discernible value, because we need to think about the Bribery Act, please send me an email, nrobertson@mayorbrown.com, with the answer to the following question. First come, first served until stocks run out, and we may have a number of prizes of no discernible value. So here's the question. In the London Zoo Tribunal case, featuring 2 women who got into a fight about a third employee of the zoo, one of the women involved was a meerkat handler, the other was a monkey keeper. What animals did the guy look after? And on a much more serious note, we've put together a really good summary of all the cases we dealt with this year on the podcast. And dare I say it, I think it is a really useful document. And looking at it, it's quite amazing to think of the ground we have covered and also the grounds that the courts have covered, developing the law and its application to employers. We're going to post a link to that document on Twitter. So if you log on Nicholas Robertson at Nicholasrober11, then the number one, so Nicholasrober11. We'll put a link up on the Mayor Brown intranet. We really do hope you find it useful. So, on behalf of the team at Mayor Brown, thank you very much. Wish you a happy Christmas and all the best for 2016. And Kayne and Tori, thank you very much indeed for being involved in the podcast.
Thanks.
Thanks, Nick.
You know, I think we could have got away with that champagne after all.
Go on, then.
Next year.
Next year. Thank you and goodbye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.